All right, there we go. All right, we're going to get started. Well, good afternoon, and thank you all for joining us today. My name is Trace York, and I'm the Associate Legislative Director for NCSL's Communications, Financial Services, and Interstate Commerce Committee in our Washington, D.C. office. A few housekeeping items before we begin today. For those of you who don't know, the National Conference of State Legislatures is the premier bipartisan organization that serves the legislators and legislative staff of the states, commonwealths, and territories of the U.S. NCSL provides research, technical assistance, and opportunities for policymakers to exchange ideas on the most pressing state issues. We also represent state legislatures before the federal government, working to enhance the role of state legislatures in the federal system. We work to oppose unfunded federal mandates and unwarranted federal preemption of state authority, and seek to provide state legislatures the flexibility they need to innovate and be responsive to the unique needs of the residents of each state. So why are we here today? Well, over the past 2 years, 25 states have enacted laws that will allow student athletes at the collegiate level to sign endorsement deals and otherwise profit off of their name, image, and likeness. In over 10 states, those laws took effect on July 1st of this year, and the pressure that states put on the NCAA has caused them to change their stance on student athletes being able to profit off of themselves. To delve deeper into what states have been doing, we have with us today two leading state legislators on the issue, including the lawmaker that authorized the very first NIL bill that was passed by the state of California in 2019. And she is here with us now. I'm very excited. But we're going to start with Representative Chuck Martin of the great state of Georgia. Representative Martin is the state representative for Georgia's 49th House District, having served in that capacity since 2003. He's also the chairman of Georgia's Higher Education Committee. Prior to his time in the House of Representatives, he was the mayor of Alpharetta, Georgia from 1996 to 2002, and a member of the Alpharetta City Council from 1993 to 1995. Representative Martin was instrumental in helping getting Georgia's NIL law passed, and I appreciate him taking the time to be with us today. Take it away, Representative Martin. The floor is yours.
Thank you very much, and Senator, thank you for joining. Thank you for joining us this afternoon. I look forward to the good exchange of ideas. What I wanted to do is just to go over a bit of how it came by and a little bit about our legislation. I guess I'm a little more familiar chairing our Higher Education Committee that this was going on as one reason, the Higher Ed Committee. But years ago, literally, a generation ago, I was fortunate enough to be part of the team at Georgia for a couple of years. One of those years when we won the national championship in 1980. So I sort of experienced firsthand the way players get pulled on for their autographs, for their images. Of course, at that time, literally 41 years ago this year, there wasn't social media, there wasn't the marketing and the advertising and the opportunities that there are today. But I saw things. I mean, I just saw players getting pulled at and tugged at. I also saw players coming from very different socioeconomic backgrounds, and where that those dollars, could perhaps help. I saw that could have happened then, and I see how in 2020 in 2021 that it could happen. I see places where kids are involved in some activities regulated by various intercollegiate associations that are able to capitalize. If one is in the band at the University of Georgia, maybe even on some sort of a scholarship, but they could record an album and sell and get royalties from that album. They could write a song and do that. So we wanted to come up with something, provided a basis for our student athletes to be on a level playing field. The senator had gotten California out ahead of us, and we're competitive over here in Georgia. We never like to leave our student athletes, the young ladies and men that are participating, that we enjoy watching, that they use their athletic achievement to help them academically and pay for that. We didn't want to leave them behind. So real quickly, to go over the bill, we tried to be very simple in it. We know we're not the experts. We had leaned on the NCAA. We had hoped to lean on the NCAA and then perhaps a single, a congressional solution that would take into account, or at least what the NCAA had done. So our bill is simple. probably the most important definition in the definition section is a team contract. We basically said there's this thing that it's okay for a team to have, and define that, and let eyes wide open their student athletes know that if you're coming to play here, you sign this, and if you then avail yourself of a contract with an endorsement, NIL, that it can't conflict with that.
Mhm.
See later in the bill where it also doesn't let that team contract be too preemptive. But that was an important piece of the bill. In operating, how it did, we talked about, we tried to do this, and I think, Senator, I look forward to your comments on it, but I think one of the trickiest things from being, involved in at a very, low level in student athletics 40 years ago, what is commensurate for their name, image, likeness? Who am I to put a number on that? But I think we know that we didn't want to turn it into a recruitment tool. So sections of the bill, address that so that it wouldn't turn into making some of the larger schools give too much of an uncompetitive advantage. And I know there's still question about larger markets. Senator, again, like California has, larger media markets. Those athletes have, I think there's a couple of young ladies at Fresno State, volleyball or basketball folks that have done real well. So we tried to address and conflicts and disclosures and notice in the bill. We also talked about the Senate came in later and they said they may pool the money from the NIL. I was a little resistant to that, but since we had it being an enabling language that the school may pool the money, that's okay, because I'm willing to let the market take care of themselves. I think if the universities try to pool too much, try to take too much from athletes, the athletes will see it's just not a good thing for them, and they decide to play elsewhere. We talked about the limit on what they could take, the procedures by which that money would have to be handled when it was pooled, how it was deposited, and how it was dispersed, and the equal treatment. The most important thing here, I think, is to make sure that everybody is treated equally, with regards to, male, female, basically all the federal protections are in there, but also to make sure that it's not geared toward, we can't drive the market, but it's not geared toward only available for the high revenue sports. This is something that we should let the market determine the value. The most important part, I believe, in our legislation is that we're requiring a workshop for the student athletes. Some of these young men and young ladies come out and they may only be in Georgia. You start school early if you want, and you could come out, be turning 18 in your freshman year of college. And so people could be reaching at you to sign these contracts, and, almost at or slightly before you turn 18. So we required our universities to provide a financial stewardship workshop so that people aren't taken advantage of. I think the worst thing that can happen here is for folks to get into their head and promise them that the money they get from this name, image, likeness is the end all, and get them to stop focusing on their academic and athletic careers, but to have a short-sighted view. So we did that. We made sure to say that the contract for the name, image, likeness could not be with a school or an athletic association associated, again, to try to stay away from the undue recruitment. I could repeat again in sections of the code that are necessary, but very clear that we didn't want to have preemptions about what the contracts could say, as long as they were not in conflict with the team contract that was done. Eyes wide open for the athletes going in. One of the things, Tracy, that you are aware of that we also put in ours, because we didn't see that we were the experts to do this, that we are intent upon letting the Collegiate Athletic Associations, university presidents, work on this. They have better views of it than we. And so we put a sunset in ours, that when the NCAA did something that would allow for this to happen and would not punish our schools or student athletes for allowing it to happen, that we would sunset our law in Georgia. And there's questions about has the NCAA done enough to actually cause our law to sunset? If it does, that would be just fine with us. I think we'd come back in next legislative session, make sure that we do some things from a states' rights perspective to make sure our athletes still get the financial training and are still taken care of. But if they are able to agree with that across the institutions, from Division I to, and down, in the NCAA and other intercollegiate athletic associations, we're perfectly fine in letting them develop those. So with that, I'll stop and look anxiously for what the senator has to offer. I'm sure I'll come up with something that I've missed, but I know the senator's on the schedule. So I'll turn it back over to you and reserve, as they say, the balance of my time.
Well, thank you, Representative Martin. I really appreciate that. I'll now introduce Senator Nancy Skinner. Senator Skinner has represented California State Senate District 9 since 2016 and served in the California State Assembly prior to that, beginning in 2008. She serves as the chairwoman of the Senate Budget and Fiscal Review Committee, as well as the chairwoman of the Joint Legislative Budget Committee. Before holding office, she was the first and still the only student to be elected to serve on the Berkeley City Council. She also co-founded an international association called the Local Governments for Sustainability, or ICLEI, which now includes 2,500 local and regional governments in more than 125 countries. As I mentioned earlier, she was the bill author of the Fair Pay to Play Act in California, which was the first law in the country that allowed college athletes to earn money on their name, image, and likeness. Thank you for being with us, Senator Skinner. The floor is now yours.
Thanks so much, and great to meet you, Representative Martin. Like every other state, California is having a high outbreak of the Delta variant, and I'm in my Capitol office right now because we have floor session starting at 2. And we have had, unfortunately, a number of our members and staff who are fully vaccinated from when they were in the office without wearing masks, got the Delta variant. So right now we still have a mask policy in the building. So you'll get to hear me through my census mask. Anyway, as was indicated, I got elected. I was first elected to office many, many years ago. I think probably similar time that Representative Martin might be at college sports, but I was a college student at Cal. You can see my Go Bears right behind me. And I was a student activist. And so, taking that tradition, I suppose I have thought about student rights a lot over my full, my 40-year or so career in public service. And my very first awareness about unfairness towards student athletes came about from the civil rights lens. And at UC Berkeley, Harry Edwards, he's a very prominent sociologist, sports sociologist. I heard him give a lecture, and he talked about how then he was primarily talking about Black athletes. And in the college sports that generated the most income for colleges, those were the prominent athletes by and large. And yet, because of NCAA rules, many of those athletes could hardly survive school because in that time, yes, you could get a scholarship, but it could only cover your educational expenses. It couldn't cover other expenses. And of course, as most of us know, if you are an elite athlete or athlete in a number of sports, that's a full-time job. I mean, other than your studies, that's all you do. So you're not really able to do a part-time job. So anyway, he talked a lot about that being very unfair. Now, my favorite basketball player back from when I was in high school even was then he was known as Lou Alcindor, now Kareem Abdul-Jabbar. He played for the Lakers at the time. And Kareem Abdul-Jabbar has spoken about this for decades. So, my interest was kind of piqued about, our athletes are kind of exploited. But again, it never occurred to me that I could do anything about it. Now, move forward to actually, it was 2016. Now, prior to that, as I'm sure many of you have recalled, there were things like the Ed O'Bannon lawsuit, where Ed O'Bannon saw images of himself as a college basketball player in a video game where he did not have to give any approval. He was no permission. He, of course, did not get any income from that video game. And there was the very celebrated lawsuit. And the lawsuit was a mixed bag. It basically ruled, hey, you can't exploit Ed O'Bannon's name, image, and likeness. However, it did not give students the name, image, and likeness rights. But I think following that lawsuit, and just every time you would turn on any kind of major sports, especially March Madness and the rest, going back now for the last 8 or so years, you would hear some commentator, either a former student athlete or just the commentator, talk about how much money the coaches were making, how much money was generated from this athletic enterprise, how much money the media, of course, was making, and yet the student athlete, of course, did not. So I always thought that that was pretty unfair. And then I learned very close at hand, I had a good friend whose daughter was a swimmer, and she wanted to go on to swimming in college. And she had gotten offered a job to be either a lifeguard or a swim instructor. And her school advised her, no, you can't take that because that would make you ineligible to be in the NC2A sport at college, which she was going to go to the next year. So as a swimmer, she could not even teach swimming or be a lifeguard. And I thought, that is ridiculous. And this is back in high school. So anyway, I heard a sports economist, Andy Schwartz, give a talk. He gave a talk at the Oakland Rotary, and he had been an expert witness at the Ed O'Bannon trial. And basically, he talked about how the exploitation of student athletes, but he gave a variety of fixes. You know, there was one, he said, look, there's lots of ways this could be approached. Athletes could become employees. And he talked about the history of how the NC2A was formed and that its whole purpose was to avoid athletes being employees. But he said, at least as employees, they'd have certain rights and they would be at least covered for injuries and such. He said also, he talked about name, image, and likeness rights. He talked about a variety of things. Anyway, so afterwards, I told him that I was running for Senate at the time. And I asked him if states could do anything about this, because I thought, well, you know, we must be preempted because it was a national issue. And he said, oh, no, actually, states can do something about it. And the NC2A's own bylaws say that that the NC2A must follow state laws. So if there's a state law that maybe differs from an NCAA policy, the state law takes precedent. So when he told me that, I told him, I said, okay, I'm going to introduce a law. Well, I got elected, and my first year I wanted to introduce a law. My staff said I was crazy. They would never get through. The schools would oppose it. Everybody would oppose it. Then my second year, well, and I wanted to make athletes employees. But when I thought about it, I realized that that was difficult because, of course, there's, you know, the amount of training, practice, and all that for different sports really varies. How would you, and not all the sports generate the revenue. And, you know, it just seemed like a difficult one to figure out how to set up. So after about the third year, my staff is still telling me no. I told them, okay, look, I'm not taking no for an answer this year. And you either come up with a different angle on how we can give student athletes, you know, a little more fair share here, or I'm going to go with the employment model. And that's when they landed on the name, image, and likeness rights. Now, our law, California's law, which was the first, has some similarities to Georgia's, or we could say that Representative Martin's law, Georgia law has some similarities to California, it doesn't matter. Now, where we differ, so we also respect the colleges in that we say that the students contract or the student's pursuit of their name, image, and likeness cannot be in conflict with any endorsement or a contract that the college has that generates revenue for the sport. Because we know that colleges do. They need to generate external revenue to support their athletic programs. So we did not want to have a conflict there. We also did not want to interfere with recruitment. We wanted to respect that boundary of, we did not want colleges to be able to offer students, in effect, okay, student, I'm going to guarantee you a contract for your name, image, and likeness if you come to my school. So we prevented that. What we did not pursue the revenue sharing that is in the Georgia law. And the reason that I decided not to do that is because I felt that I just wanted it simple. So we stuck just with the straight name, image, and likeness. And there was a committee that wanted us to require a financial literacy course. And I personally feel that all college students, actually, I feel all high school students should have a financial literacy course. But I didn't want I didn't put it in our law because I did not want to, it's like somehow say, okay, student athletes are like dumber financially than other students. Because when you think about this whole realm today of what students do and how much money they can generate, think about it. Zuckerberg formed Facebook when he was in college. Sergey Brin and the other founder of Google were in college. There's so many college students now who are generating, whether from patents or coding or TikTok, YouTube, you name it, whatever it is, they are generating lots of money. And so clearly it would be beneficial for all of them to be financially literate. So I felt like, okay, I'm not just gonna carve out just student athletes, though I would support financial literacy for everybody. And other than that, I think the laws are pretty similar, though we did not have any sunset. We felt that NC2A, we instead set our law to not go into effect until 2023, because we figured, okay, ball's in your court, NC2A, you can fix this. You already had a commission. Condoleezza Rice was the chair of your commission that advised you that you should give students name, image, and likeness rights, and you ignored it. You've had various lawsuits, you're still ignoring it. So we'll give you a few years. And then if you don't do anything, our law goes into effect, and our law is then, we don't care what you do. Now, of course, you had the Supreme Court ruling, you've had NC2A saying people should have name, image, and likeness rights. We're speeding up our law at the moment. It will actually be on consent. My new bill, SB 26, which will put our law into effect as of September 1st, will be on consent calendar on the floor of the assembly this coming week. So we expect it to get on the governor's desk before August 31st. And so that our students, every student now has name, image, and likeness rights because of the NC2A's own ruling. However, we wanted to make sure that our colleges had the protections and the other things that were in our law. So that's why we're speeding up the ability for our law to go into effect as of September 1st.
Thank you very much for those remarks. I guess to kick off the Q&A part of it, I guess I'll just kind of touch on what you just mentioned, Senator Skinner. So the NCAA has came out and once California and then other states started following, introducing these laws, they kind of changed their tune a little bit, and now it's a lot more official that they are more in favor of the.
Well, I think that Supreme Court ruling had a huge bearing on it. I mean, of course, I'm sure Representative Martin and myself, we want to take a lot of credit that it was us, but I think that court ruling that said, hey, sorry, NC2A, you're not above the law, and we're going to hold you to what's the legal standard, antitrust. That you are, you're not inviolate of antitrust laws. So
So I guess the first simple question would be, and and Senator Skinner, you kind of touched on it, but I mean, is the changes that or reforms that the NCAA has announced, I mean, is that satisfactory to you? Does it accomplish the goals, or is it still falling short of where you think things should be? And then Representative Martin, I'd be curious to get your thoughts as well.
Well, on one level, if the NC2A right now, from a state rights perspective, from a student athlete protection and a state rights or student athletes' rights, state rights, it's kind of the right decision because it says, look, we're not going to interfere with your name, image, and likeness rights. And then it leaves it to the conferences or the colleges to figure out what they think is appropriate. Now, my guess is, so I would be fine with just leave it, right? And let the states figure it out in the conferences. However, I think there's going to be enormous pressure just, to come up with a national. And what I worry about that is that the national rule, you think about, money is very powerful. The powerful interests here would be obviously the campuses, the coaches. I mean, look, there's coaches that are paid $5 million a year. And then of course the media markets. So, I hope that if there is any type of national action, whether it's by Congress or by the NC2A, that it puts the students' rights first.
Representative Martin, what do you think?
Yeah, a couple things. I want to go back and make sure I was clear. The senator mentioned about not putting the matching or the pooling of the money in there. I want to, the revenue sharing, I think it's the way the senator said. I just want to be clear, when that is enabling legislation in our code, and the revenue sharing is among the NIL money. It's not revenue sharing from ticket sales and so forth. And Senator, I'm not a big fan of that either. I don't think it actually is going to happen, because I think if for instance, other conferences, our friends over in Alabama and Florida and South Carolina, if they don't make their athletes share, and Georgia colleges do, I think we will lose some of the athletes to that. So just to be clear about that. Senator, we always have fun with our upper and lower chambers here in Georgia, so I'm just going to say that was a Senate idea that had to get in there. So I'm going to let my Senate colleague know that California Senate didn't like that one. But back to your point, Trace, is I think from what I know that the NCAA and the conferences are going in the right direction. What I am most concerned with is, and what I am sure this is done, if you talk about the coaches at large and small colleges, because there could be a small college someplace that has an athlete that nowhere with a name, image, likeness issue from having a great Olympic, debut or a great Olympic performance. It's not necessarily that the people that have the big money associated with their name, image, likeness may be in all the Power 5 conferences. They may be at a smaller college. Mm-hmm. What I am sure this does for all the coaches is, in football, they talk about the 3 phases of the game: offense, defense, and special team. Mm-hmm. This is a fourth phase. You now have to manage this, because in the NFL, sure, there's the $20 million man and the person that's making the league minimum, but the league minimum is pretty good money. Yeah. And I don't mean to be flippant about it, but I mean, there's a reason for that. They have a players association. Over here, you're still going to have the marquee athletes that are your mm-hmm. skilled folks in college, or your shooting guys in basketball, or the home run hitters in the baseball team, the class, world-class gymnasts over there, and they're going to be on the teams with people that don't have that. And what I'm really concerned with as we roll that law, because the kids, and I hate to say, I mean, no disrespect when I say I'm kids, it just basically says more about my age than it does about their, youth. But these athletes have to realize that there are still going to be people that have the big name, image, likeness contracts and opportunities living right next door and seeing every day to their colleagues that don't, within the sport, much less across the sport. So that's my concern. I would love to see at some point the NCAA get into a place that along with your scholarship came a stipend.
Yeah.
You call it a salary, call it whatever. I mean, when kids, go to college, and again, I'm back to the kids, when young people go to college, their parents, whoever sends them, and, not all the time, but they don't just send them off. They usually send some financial support with them.
Yeah.
Some folks don't have that. Or so if an organization is going to bring you on scholarship to do that, they need to do, in my opinion, some work to figure out what that stipend may be.
Yeah.
And as the senator said, the pushback or the issue there is, if you're a Division I football program and you have 90 scholarship athletes, and then you have some walk-ons, et cetera. Well, if you all of a sudden say that stipend is $400 a month, you've just added that times 90 times something to a budget.
Right.
If you do it for football, because it's a revenue producer, you really need to do it for the non-revenue, net revenue producing sports. And that's without regard to the gender of the sport. Ladies basketball, softball, I mean, they are high revenue generating sports as well. So I don't want to, I don't have the answer for that.
Yeah.
I kind of pose that as some more work left, but the NCAA is moving to let the individuals be compensated for their name, image, likeness. And I think this is a first step toward keeping these student athletes in school and not making them feel like they have to go out after 3 years of baseball or after 2 years of, or 3 years of football. It lets them stay and be student athletes, because as the NCAA says oftentimes in their commercials, these student athletes go pro in a lot of things besides the sport they play in college. They're very integral to our communities when they go back into them, and that education is important.
Yeah.
So one thing that I'm kind of interested in is, some people have made a lot out of, protecting the student athletes sometimes from themselves. There are various restrictions on the type of contract that a student athlete can sign, or can they sign with a company that's a competitor or of the university that they're at, various types of restrictions. Can you just quickly, what are kind of some of the restrictions student athletes are able to earn, but it's not a complete Wild West? Are there certain restrictions that your individual laws put on the types of deals that student athletes can sign, or what are the restrictions as far as the university that they attend, or are there not any at all? Can you expand on that a little bit? And we can start with Senator Skinner.
So, well, first on Representative Martin's comments, I mean, I appreciate that, by giving the students the name, image, and likeness, which when I say the students, student athletes, which all students already had. The only students that didn't have it were the athletes, because they forfeited it when they signed their, agreement or their contract with NCAA. Now, in doing it, it doesn't necessarily create fairness, because there are some of the students who will be able to exploit or take advantage of their name, image, and likeness in far greater ways, more monetary beneficial ways than others. However, we also have the thing about that restriction is that it wasn't just related to athletics. You could not, I'll give a great example. So there's a young woman who was in her school was an NAIA school, not an NC2A. And so she got the name, image, and likeness rights earlier. She goes to the school, Aquinas College in Grand Rapids, Michigan, where she makes her money. She's a do-it-yourselfer, and she made all her money on TikTok. And at first she couldn't monetize it because she was also a volleyball player. But as soon as they lifted the rules, she started monetizing, and she's made an enormous amount of money just doing her do-it-yourself projects. So you could have the students, these student athletes, now making money off different things and not just their athletic prowess. But it still doesn't create quote unquote fairness, because the top athlete, as we have seen from the who's the quarterback that is, right now, they're already,
Alabama.
say the name.
Was it Alabama, the quarterback for
Yes,
Alabama?
yes,
Yeah.
yes. I mean, the amount of contracts he's already signed, quite remarkable. But anyway, but now let's go back to your key question. Our law, California's law, would restrict the athlete from a contract that conflicts with a contract that the college had. So for example, let's say Nike is the supporter of, I'll use my alma mater, Cal Berkeley, the Bears football team, and all the Bears were wearing Nike shoes. You, the student on that team, would not be able to get a contract with Nike. However, you might be able to with someone else, but you can't have your contract conflict with official team activities. So that's the way that we structured ours. Otherwise, they can sign a deal. Say like if Cal Bears had it with Nike, you could sign it with Adidas. So we didn't say because your team has a contract with the athletic shoe, you could not do athletic shoes. No, just not with that particular athletic shoe. So that's what we did.
Representative Martin?
Yeah, very, very similar, because I think the other thing you will probably see in some of the team contracts is you may see some products that are excluded, that you can't use your name, image, likeness. I think one of the things, if I'm not mistaken, that the NCAA did either reference or put into theirs was that you couldn't have your name, image, likeness promoting I think sports, gambling and the like. I mean, just things that you already see in major league sports to keep the process pure. And the senator brings a great point. A lot of these student athletes have just developed a persona. It may have started with sports on social media, but it's taken a life of its own in a very vibrant and healthy and positive way. But they weren't able to monetize it, and now they can. So sometimes it may have been started on their athletic prowess, but not so much. It's just taken a life of its own, so they can do that. But I concur with her. Basically, it's if you're at a Nike shop, you can't sign on with Adidas or vice versa. We don't give anybody free shout outs. I don't think that we all know what those.
Right.
Yeah. So I know that Senator Skinner has to run to the floor here in a little bit. So I guess I'll wrap up with one final question, and you guys can answer it however you'd like. Is kind of where do you guys see the debate going from here? You have half the states in the country now passed a law enabling students to profit off of themselves. The NCAA has now came around to that view, and they're still developing things. There are a number of bills in Congress that would preempt all of the state laws, but the states have done really the main job of kicking off this debate to begin with. I don't think anyone would say that the NCAA would have changed their tune had the states not put pressure. So where, in your opinion, where is the debate going from here? How important has the state action that has been taken? How important has that been to allow student athletes to do this? And just kind of any final thoughts to wrap up the session. And Representative Martin, we'll start with you.
Yeah, well, I mean, I hope the conversations go forward are, good, positive, and productive, and are heading us toward a approach where consistency can be achieved, and not necessarily, like the senator said, we're never going to get pure fairness. I mean, it's your value or your value to a company that they wish to promote is going to be what it is, but a consistent view of how it's implemented. I know we in our bill referred to national action, but that would have been recognizing the NCAA, and I don't mean this to at all be a partisan statement when I make it, but I think that the closer government to the people is the best, and I think the wise souls, the 400 plus and the 100 senators in Washington and are not necessarily in a place where they can do a one size fits all. I mean, at the end of the day, a statement many times, overused, but true. They don't know what's best for these student athletes more so than these presidents and the conferences that are working with them every day. So I would hope going forward that we have a positive, productive, approach that comes up through the people that are working with these student athletes every day and see the situations that go. I oftentimes say that there's 180 House members, 56 senators. We have a governor and a lieutenant governor, and we have almost 11 million Georgians. The best ideas don't necessarily come from inside the Capitol. So I see this process in education going forward with directors of athletics, and college presidents, coaches, players that have had things like the senator mentioned with the young athlete that was, a do-it-yourselfer. I mean, we're going to have these one-off situations that are going to come up. So I hope the approach just we can achieve a sense of consistency, and I hope that we don't break the amateur nature that is college athletics, because I'm biased, but I love my pro sports to see that. And that's what people do for a living. But I think these student athletes, it's a special time and a special place in their life. And I hope this allows them to gain from it, and we don't take away from the sport as a whole.
Senator Skinner, final remarks.
I think the good news about the fact that all the states have acted, and that now the NC2A has said, students, you've got your name, image, and likeness rights now. You've got the student athletes now paying attention, and more of them are joining, the Players Association and things like that, so that there will be there's always been a voice for them, but it's not been that, it hasn't had the involvement of student athletes from across the country. And I think we're going to see that now. And that's a good thing, because otherwise they're not really at the table in terms of what should be fair, what's right. Now, I personally like states' rights, but I think in this regard, I really think the students' rights have to come first. So, we're not discussing, I think it's interesting. A student who's in say if I take, again, my example of my alum school, the UC Berkeley. UC Berkeley happens to have the bioengineering and genetic lab of Jennifer Doudna, the recent Nobel Prize winner, that did the gene editing that led to, for example, our COVID vaccines and now COVID treatments. Well, there are no restrictions on, for example, the chemistry student or the biology student or the engineering student or the computer science student. And given the type of advances that are occurring right now, it's possible you could see one of those students getting either a contract or breaking through something and make at least as much money as our quarterback at Alabama. But we're not debating should there be a rule, either nationally or state by state or whatever, for those students, because we've just taken for granted. We've never thought about or worried about the name, image, and likeness rights of other students that they all had. Now, I think I shouldn't say the only, what I would, if there were to be some type of push for a uniform policy, then the type of uniform policy, again, I would want to make sure put students' needs and rights first, but also protected the colleges, because the colleges do generate revenue. They need to generate revenue for their athletic programs. And I don't want to get in a situation, because I want there to be lots of different sports for students to participate in. And if the college isn't able to generate a good amount of revenue, they can't always support other sports. So I like the diversity of sports. So I want to make sure that whatever is done, the colleges can still generate revenue, but I think student rights also have to come first.
Well, those are great finishing comments, and we will sign off for today. I want to thank Senator Skinner and Representative Martin for joining us today. We really appreciate your time and expertise. It's been great having you guys on. And thank you to everyone who tuned in today, and NCSL looks forward to working with you all on this issue going forward and into the future. So thank you again, everyone, for attending, and have a great rest of your day. Thanks.
Thank you, Tracy.
Thank you, Tracy.
Thank
Representative
you.
Martin. Thank you. Okay,
You bet.
bye.